So, welcome everyone once again to today's session where we are going to discuss the Corporate Law Amendment Bill 2026. And in this session today, we're going to have two of our esteemed speakers. First one is Amita Desai. Amita Desai is a practice head of corporate secretarial practice at Incorp Advisory and now Ascentium India. She is also the co-founder of the organization. Amita comes with she's a very seasoned professional with around 30 plus years of experience advising on corporate governance, compliance, and secretarial practice across the Compliance Act, FEMA, securities law, and M&A. Known for translating complex regulatory requirements into actionable strategies across IPOs, restructuring, foreign investment, and ESG compliances. She is also a fellow member of ICSI and registered insolvency professional. So welcome Amita to the webinar. And today she will be joined by Mr. Anuch Trivedi, who is a seasoned lawyer and he's a partner at Denton's Link Legal. He comes with a 20 plus years experience in corporate and commercial law with deep expertise in M&A, foreign investments, and transaction structuring. He is recognized by Asia Law, Legal 500, and Legal Era for excellence in corporate legal advisory. He has advised domestic and multinational clients on regulatory frameworks, compliance, and commercial contracting across sectors. So thank you, Anuj, joining us today for this very insightful session along with Amita. I'm going to now request Amita to take it over and please present her presentation and give us her insights. Thank you.
Yeah, thank you, Dolly, and good evening, everyone. Dolly has already set the context about what we are going to discuss. I think I'll just start sharing my screen. Just 1 second. Give me a moment. Dolly, is it visible?
Yes, it is visible. And before Amita, you actually begin, it is important for me to add that today we are going to cover only the part 1 of the announcement, the bill, and part 2 will be covered in the following week. So we request all of you to stay tuned with our LinkedIn and whichever means that you all connect with us, and we will let you know about it shortly. Also, throughout that session, if you have any questions, we request you to put it in the Q&A section of the session and not in the chat section, which will be taken up by our experts towards the end of the session. Okay, Amita, you please take it forward. Thank you.
Yeah, thanks, Dolly, for clarifying that this bill itself is a lengthy bill. There are many changes in the LLP Act and the Companies Act, so it needs two separate sessions. And today we both will be speaking maybe 20 minutes and covering few of the sections which are very important. So coming to the introduction and background of the bill, recently on 23rd March, the bill, which is a Corporate Law Amendment Bill 2026, has been placed and introduced in the Lok Sabha. Lok Sabha has directed this to the Joint Parliamentary Committee for the examination, and once the Joint Parliamentary JPC will approve it or give the suggestion, it will be placed in the Lok Sabha, Rajya Sabha, approved, and then assent is given by the President, and it will become a law. But before that, after becoming law also, Ministry of Corporate Affairs can make a different dates of its effective or implementation date, like we have seen in the past. Further, this bill is completely based on the Company Law Committee report of March 2022, and there are many changes which will aim for ease of doing business or decriminalization and bringing the clarity and removing the ambiguity. That's the purpose of this bill. And bill is still not addressed certain recommendation given by CLC to 2022. And again, as a disclaimer, these are all our personal opinion, and you need to seek the actually expert advice for anything. And this is just a bill, not the act as of now. This is just a proposal. So the proposal of Corporate Law Amendment 2026 bill is two types, like LLP Act is also amended and the Companies Act. We have seen LLP Act has been enacted in 2008 and one change in 2021, and this is the proposal. Whereas the Companies Act 2013 has been already amended number of times, and this is the final proposal. I will just quickly touch upon the LLP Act, though there are not multiple or many changes, but With LLP Act, the LLP Act itself has recognized IFSC, that is IFSC A and IFSC and permitted foreign currency, and specified IFSC LLP definition has been included in the Act. A register office all the time of IFSC LLP should have register office in IFSC. The name should have a suffix that it is IFSC LLP so that any person can address and understand where it is registered. There are ease of doing business for the incorporation of LLP also, a self declaration. No need for, unless you engage the professional, you don't require. So the trust has been imposed on the person or the partners that they can self declare that the company LLP has been in compliance with the regulation and is incorporated. Similarly, prescribed section 23 and 25 ask for, apart from SEBI IFSC, they also need to intimate certain forms of the classes which may be prescribed later on by central government to the registrar of company for the better governance. A form of contribution is again permitted into the foreign currency, any permitted foreign currency. Electronic filing also in a different foreign currency is permitted now. There is one more appellate authority is been inducted, or it's been added in the law, where you can make an appeal against the provision or against any of the ROC or RD's orders. Adjudication of penalty also, suo motu application can be filed, which was not provided into the law. Adjudication penalty, again, the central government is deriving power wherever there was a fine and now it is moved to the penalty. They can withdraw or transfer the matter from the court to the regulator itself. So these are the major amendment in the LLP Act. Coming to the amendment in the Companies Act, the purpose of the bill is ease of doing business. There are multiple relaxation and decriminalization given into the section which are put on the left hand side. These are all sections where there are multiple relaxation given. Ambiguity has been cleared in certain section, empowering central government itself to make the provision for the prescribing the class of companies where there will be exemption, or setting up an authority, or setting up the fund also. We see there are two setup of the new funds, NFRA fund and Consolidated India fund, where there is a penalty. The penalty will go into such kind of a fund, and there are two standards which may be prescribed by the regulatory authority, maybe cost standards and the valuation standard. Further, here also the trust is imposed on the company, corporates, and business owners that they give a self declaration required for the incorporation, also for the buyback. Also, the declaration of solvency can be on the, instead of an affidavit, it can be a plain paper self declaration. And further relaxation is given that no audit is required. So the trust is imposed on the corporate and business owner that they will disclose audit requirement, but this audit requirement, no auditor is required is for maybe very small or ultra small companies only. Those companies will be prescribed by the central government, which will be in the public interest. So these are the major purpose of the amendment or the bill. Now we'll see what are the ease of doing business in this proposal. First and foremost, I think the small company definition, it is increasing the threshold. The lower limit remains the same of the paid up capital 50 lakh and turnover 2 crore. But the upper limit, which was earlier 10 crore, now it has been increased to 20 crore for the paid up capital, and for the turnover, it will be 200 crore. I think this is a ease of doing business. Many of the companies will be now under this criteria of 200 crore of turnover is a quite a big number, where many companies will fall under the small company. However, certain companies still will be outside the small company definition in spite of touching those threshold. If it is, I mean, not touching the threshold, but still, if it is a subsidiary holding relation, Section 8 company, or any body corporate governed by any special act, will be still not be a part of small company. We'll see where there are a number of exemption and privileges available to small company, which will be now, due to the wider coverage, will be very useful for many ease of doing business. Like no compulsory demat is required for a small company. Fast track merger they can avail any two small company. They have a special lesser penalty provision, half of the penalty of whatever the prescribed in that particular section. One board meeting in a calendar year. There is no rotation of the auditors required. There is no applicability of IFCR, that is Financial Control, and CARO 2020, that is been exempted for small company. PCS certificate for various form filing with ROC is also not required by any certification of professional. A breach for report for board and annual return in forms 7A is also required, which is very, I mean, it's very small and not very lengthy like a large corporation. Exemption is given from cash flow statement, also not required to be provided. With reference to ease of further doing the business, we already discussed in LLP, similarly in Companies Act also, the first director or the first promoters or the designated partners can give a declaration. No need to have a professional, unless professional is specifically engaged, then he has to give the declaration that the compliance has been followed while incorporating the company. Service of document also very ease of doing business. You don't have to print and post and do a physical submission. You can always circulate to your member through the email, because email IDs are always available. So in the digital era, with the protection of environment, this is a very welcome move for servicing to the members. Share capital, we have seen in IFSC that permitted foreign currency is allowed for keeping the books of account, issue and converting the security, or filing the documents with ROC with the permitted security. Ease of doing business, further to the allotment, I think I will skip this for buyback and private placement. My next speaker, Anuch, will be speaking about this, so I'm just skipping this. Register of charge also, I think this is a very welcome move. Within 60 days, if the company is unable to register the charge, then there was no further provision, where now the registrar has been empowered that he, with the approval of one, within application to be approved within 120 days, he allow if the company will pay the advisor fees. So such charge can be now registered with ROC. Virtual meeting will again see, but this is the ease by having the physical meeting, or instead of physical meeting, a virtual meeting, and physical meeting once in 3 years. Virtual meeting, again, notice can be given by lesser than 21 days, because just nobody is required to travel and attend the meeting. So virtual meeting notice can be less than 21 days and make it 7 days. Certain CSR exemption, we'll see there. Relaxation, already we discussed, the audit relaxation has come in. Resignation of KMP was a big hurdle. Sometimes company is not able to file the resignation, then the person who is a KMP in the next company cannot file. He is not able to file his DR 12 also. So this is a relaxation given to the KMP to register his form with the registrar. Again, I'm not touching this scheme of arrangement. My next speaker is going to take it elaborately in the scheme or arrangement. What are the relaxation? Appeal to restore the company when the ROC has registered and strike off the company. The appeal used to go to NCLT, where there is a to declog the NCLT. This power is now given to the regional director. He can decide and visit and make an application. You can restore the name of the company by convincing the RD for the reason what he felt correct, and that application need to be made within 3 years. Certain fees also, there was a lesser fee for filing of financials and annual return, just 100 rupees per day. But again, central government has empowered itself that certain class of company, it can still give a less than 100 rupees also for filing. That is a ease of further doing business. And by that, ROC will be able to get all the data available and financial annual return of many companies, so that they are on track. Lesser penalties further for the small company, OPC, startup producer company, already it's liable for half of the penalty. Further, it can be reduced, and there is a upper limit has been put for the company, 2 lakh maximum, and officer in default 1 lakh. This is again a welcome move for lesser penalties. The separate settlement of contravention has been brought in for the first time in the statute. My next speaker, definitely Anuj, will be taking care of that, so I'm not taking in detail. Appellate authority, already we discussed that after regional director's order, there is one more appellate authority will be set up within the central government, part of the regulatory, not the judiciary. It can be appellate authority under the central government, and where you can go for the appeal of RD's order. Faster exit, because I think incorporation easy, but when you want to really close down the company, it's a nightmare for many people and many companies. So a summary liquidation provision has come in for the small company, very small company where the assets are just 1 crore rupees. So section 361 read with 271, the appointment of insolvency professional is possible to strike off this kind of a company, or liquidate, not strike off, but liquidate the company in a faster way. One more welcome move for the foreign companies and the branch where there is a contravention, they don't have to pay the fine, go for the criminal prosecution, everything, and they can just simply pay the penalty, adjudicate the matter with the regulator, and it has been decriminalized, particularly section 392. There are this all sections are where central government has brought in further decriminalization, moved from fine to the penalty, and the application can be moved with the registrar of company. We'll go to the general meeting. We already discussed the general meeting can be with the virtual and video conferencing facility. After COVID, we have seen that physical presence was very difficult during that time. So the virtual was allowed, but this provision was not in the statute. So ministry used to give every year circular after circular for AGM and AGM, and the modalities how it should be functioned and what are the conditions to be followed. Now, if the bill is approved and finalized and the rules will be followed, basis this, now it will be part of the statute that AGM and EGM can be by virtual mode with the audio video conferencing. But at the same time, provision has been made that one AGM, at least in a part of 3 years, should be physically held. That is for the listed companies or companies, large companies, where shareholders and members would like to meet the management, to the directors, ask certain questions, because in the virtual meeting they may be sometime blocked, or due to technology they could not ask certain questions. So at least 3 years once the company should call the AGM in the physical mode. A requisition meeting can also be through the hybrid mode if the requisition is made by the members. That's provision is possible. Section 99 was a penalty provision. Now it has moved, I mean, the fine to the penalty. The punishment for only default in calling the AGM will be moved from fine to the penalty. The registrar can penalize. Shorter notice, we already discussed. If the EGM is called through the virtual meeting, you are sending all the EGM notice and documents through the electronic mode, email, and notice of 7 days should be sufficient. In case of emergency, this will be the final 7 days timeline. We'll go to the corporate secretarial social responsibility. There are a number of relaxation. Net profit has been reduced for the applicability. Company is applicable to pay 2% at least for the CSR, where there is a net worth of 500 crore, turnover of 1,000 crore, and net profit calculated as per 198 up to 5 crore. Now the threshold is increased to 10 crore. So companies where the net profit is just 10 crore or below that, it is not required to have a mandatory CSR obligation of 2% spent on the social responsibility. Time limit for also transferring the ongoing project will be extended from 30 days to 90 days, because time goes for separately opening the bank account every year for the CSR fund transfer for the ongoing project. So that's also a welcome move. No CSR committee is required if the total spend in a year is now 1 crore. Earlier it was a 50 lakh remit. So the board can itself decide where the CSR committee, whatever role was there, can be done by the board, and board can decide. Further, CSR obligation can be prescribed for certain class of companies totally exempted, so they don't have to. Maybe for the ultra small company. With respect to the director's qualification for the independent director, this other clarification has come that any person who is in employment with the company holding company for past 3 years, now it is also covering the current financial year also. Similarly, no person can be independent director appointed if they are employee, proprietor, or partner of all the auditors firm. But here, earlier it was mentioned PCS, practicing CS. Now it has come to the secretarial auditor in line with the other auditors. Similarly, any legal and consulting firm's employee, proprietor, or partner can be independent director if such firm total their turnover is less than 10% of the total receipt from this company. Though the CLC has recommended 5%, but currently the bill says less than 10%, they can be exempted and they can be appointed as an independent director. A further amendment has come about the independent director. He has to ensure that he follow and he fulfills all the requirement of independence criteria throughout his tenure. And during the cooling off period between the two, repeatedly term of 5 years, and then there's a cooling off period of 3 years, he can, if he wants to be appointed further, then he has to ensure that he should not be appointed by this company holding subsidiary or associate company, and he should also ensure that the firm where he is an employee, that firm should also have a receipt less than 10% from this particular company's advisory or anything. Term also covers now the additional director's appointment. Any independent director appointed as an additional director, and then he is regularized by the shareholders. That term also is now covered in his 5 years term. With respect to the DIN, active DIN is applicable now all the time. Director has to ensure that his DIN is continued or activated. It should not be deactivated or cancelled. And the new provision has come in that KYC document should be at such interval to be given to central government for any change of name or his address. DIN deactivation due to any disqualification, he will be violating, and consequences is he cannot function. He has to step down. If dean is cancelled, then he has to vacate the position as a director immediately. First time in the statute, there is a surrender of dean provision has been mandated here in 154(6), and to restore the dean number, again the fee has to be paid. A term of additional director and casual vacancy can be appointed by the board member, but he has to ensure, it has to be ensured that the term will be next AGM or up to the period of 3 months, whichever is earlier. So the similar thing is in the LODR or the listing regulation. The same provision has kicked in here also. So the board has to ensure within 3 months they have to call the general meeting and regularize the director. One more amendment has come that a person could not be considered or could not be approved in general meeting, could also not be appointed by the board without the approval of the prior approval of the shareholders. One lacuna which I find here is the section 161(1). The language has been deleted that any person who fails to get appointed as a director in general meeting, they have to keep this word because of clarity, because board doesn't know otherwise how which person could not be considered or could not be approved. So here I think there is a need for, when we see the final bill with the suggestion, this could be, I think, cured properly. With respect to disqualification of director, earlier there was a mention that if the director is convicted for an offense of a related party transaction, now it is changed to the subjected to the penalty of default. If he is penalized, then he will not be qualified as a director. One more tricky situation has come here, that auditors, valuers, and insolvency professional, if they are providing the service preceding 3 years and current year, he will be disqualified to be appointed as a director. This is a roadblocker for the register valuer because he is appointed for a small task and then he is not able to join the company as a director. A new concept has come in, fit and proper person, and that certain class of companies ministry will appoint and decide what kind of companies will be required a fit and proper person. Again, it is in alignment of the NBFC rules and RBI rules. Duties of directors, there is one more amendment has come where earlier there was a 3 years continuously the company has not filed its balance sheet or annual return, the person will be disqualified and he fail in his duty and has been for 5 years he will be debarred as a disqualified. Now the provision has kicked in, he will vacate the office also. Number of directorship, 20 companies, maximum a person can be a director, 10 can be in a public company. However, the government has said that it will prescribe lower number of companies or class of directors where a person can be appointed. This is to give the sufficient time for fulfilling his duties. Contravention of duties, I think again it has come to the fine to penalty, and first time the new provision has come in that listed company and unlisted company separate penalties are there. Just 2 minutes, I'll just wind up. I'm just overshooting my time. So, uh, with respect to the resignation, we already discussed that KMP can file his own resignation form. Of course, he has to comply with the employment rules. He has to give the notice to the board. But if the board and the company fails to file the form, then the KMP, who is other than director, he can himself file the form. With respect to compromise arrangement, I'm leaving everything for Anuch to take care. My next speaker will give the proper justice from the law side. At the last slide, that what are the recommendation of JJ Irani, and also in the CLC board report, also CLC report 2022 says that has not yet we see in the bill are with respect to the fractional shares, permitting distressed companies to issue the shares, a joint audit risk management compulsory committee, and SPEC, which is recognized as a special purpose acquisition company where it can list in India, overseas. Producer LLP is still not in the statute. We do not see a statute providing a maintained register electronically with the central government, and standardizing qualification by the auditors, and extend holding of shares in the name of joint venture under section 187. I think I'll stop here, and thanks for giving this opportunity, and we'll be happy to take it later in the next session. I pass on to Anuj to deliberate further on the balance part, because there's a lot to talk and we are short of maybe time, and we'll touch upon. Thank you, Dolly, and thank you, Anuj. We'll be happy to ready for the question, answer, and anything. Over to you, Anuj.
Thank you. Thank you, Amita. So thank you for the insightful session. Let me just project my presentation here. I hope it has come up for everyone. So the presentation that I'll be dealing with, of course, is not so much on the secretarial side. As a corporate M&A counsel, I would be analyzing the Corporate Laws Amendment Bill 2026 primarily from a implication on on M&A and corporate restructuring, corporate structuring perspective. So, as I look at it, broadly speaking, the key regulatory framework which is getting impacted by the introduction of this bill is looking at ease of doing business. The purpose of this legislation primarily is to modernize the existing corporate legal framework which is there in India. It is towards moving towards more of the European concept of corporate law where you are decriminalizing the offenses, most of the offenses, adding more visibility to the investors and the acquirers and the stakeholders, uh, evolving the corporate law with the growing market practices and global investment expectations, and also the impact on deal structuring and compliances, basically. Now, in light of this, what has happened, and I think one other aspect, I think Amita ji has already covered it. One aspect which I feel also demonstrates the legislative intent here is that unlike other statutes which are forwarded to joint parliamentary or rather to a standing committee for parliamentary scrutiny, this bill has been forwarded to the JPC, which is the Joint Parliamentary Committee, which clearly demonstrates that the government also understands that the changes which they are trying to basically bring in needs a broad level consensus from all parties, and they do not wish to basically bulldoze their way on the legislative reforms. They are looking at a more participative uh, dialogue on these bills. Uh, the next slide is basically on the first aspect that I would be dealing with, which is adjudication and decriminalization. Now, across this presentation, the endeavor has been to basically tell you the current position under law, then briefly touch upon the key changes and also talk about the key implications. Now, historically, as most of us know, there was no formal settlement mechanism for procedural defaults which was prescribed. Primarily, in case of a violation of corporate laws, you would end up either before an NCLT or before a registrar of companies for a compounding. This basically led to prolonged proceedings, adding to workload before NCLT and registrar of companies, which led to inordinate delays. Also, there were a lot of offenses which were basically difficult to envisage as to what will be the final amount, particularly in M&A transaction, because the concept was primarily around continuing defaults. You had per day penalty, and as long as the default continued, the penalty also continued. What has happened now is under the bill they've come up with something which is similar to the US DOJ kind of a settlement mechanism, wherein a party in case of a breach can approach the specified authority, disclose that it has conduct or there have been certain offenses, and come up with more like a settlement with the authorities. Now we will come to the aspects of this on the M&A side. The other aspect which is important here is the cap on continuing penalties. Now, instead of a per day penalty which was keep on accruing, the law now proposes to provide a cap. So there is of course a floor, and there will be a cap that irrespective of the amount of delay, the maximum penalty for a particular offense will be X amount. Broadly speaking, this penalty has been capped at 5 lakh rupees, but for of course for serious offenses, this can go up. Other thing which has happened is that it is now there is a decriminalization of procedural defaults. The officers where, or rather the act where most of the provisions where an officer in default would be otherwise liable for imprisonment, all of that has been changed now, and the word which is being used is now penalties. So the endeavor is to basically decriminalize the offenses and look at a monetary penalty for offenses which the government considers are procedural in nature. Now, coming on to the corporate and M&A implication of these legislations, of course, from a due diligence perspective, typically those who are coming from an M&A background would know that the biggest challenge in an M&A transaction is predictability of the liability exposure. You would negotiate a transaction for 2 months, but last 5 days would be dedicated to discussions on indemnity and damages and all of this. This is primarily the reason because you cannot envisage the exact penalty or the exposure of the company. Are As we look at it, these changes, if whenever they are legislated in whatever form, would basically result in a situation where acquirers will have a lot more clarity on the liability exposure. It would also reduce litigation and the pre-closing compliances, which would be much more smoother. Today, you have escrow structures which are brought into place because there is no visibility on what is the final exposure that a company is going to have. With capped penalties, of course, all of this will become pretty much quantifiable. Linked to this topic is the recovery mechanism and a pre-deposit concept which has been brought in. Today, in case of an appeal, there were a lot of cases where an award is given or a judgment or a ruling is given against a company, they would simply go in for appeal. What has been done now is to basically bring in a lot more fixation of rather responsibility. What has been done is that in case of appeals, a company would now be required to make a pre-deposit of at least 10% of the adjudicated amount, which would not only reduce frivolous appeals, but would also, in case of an M&A sphere, there would be a lot more pressure from acquirers or investors to not go in for frivolous appeal, or if they genuinely feel that an award is or adjudication is not in their favor, they would basically ask to keep only this 10% amount in an escrow. Why this becomes important is there is a concept of recovery officers which has been introduced, which gives a lot of enforcement powers to these officers. Now, these officers now would have power to attach assets, freeze bank accounts, seize property, and even go ahead to an extent of arresting the defaulters. Now, as you can basically envisage, the concept here is that the government is trying to look at a pretty strong enforcement mechanism for recovery of pending dues. From a from an investor perspective, the pending penalties are now equivalent to operational hurdles. Tomorrow, in case, or rather in the current law, in case there are penalties, then there are no operational hurdles. You can keep on fighting, the matter can go on for 5 years, 6 years, and then a final penalty comes. Today, when an investor is investing in a company and the due diligence findings suggests that there have been non-compliance, the investor will basically put a lot of pressure because they would realize that a recovery officer can actually come and seize the assets, which would have an operational implication on the target. Now, moving on to the next stage, next slide. The other important change which has come up is the expansion of the ESOP concept. Now, I wouldn't say that these concepts were not there. In practical landscape, whether it is restricted stock units or stock appreciation rights, both of these concepts were pretty much in vogue. The only challenge was that the Companies Act did not formally recognize them. And therefore, it resulted in a situation where companies would issue them as a contractual arrangement, but investors would always be in a dilemma because there was I would say, a wrongful classification of RSUs or SARs, which are stock appreciation rights, which are typically not ESOPs, but they were basically bucketed or classified as ESOPs, so that to draw a legislative stamp on the instrument which is being issued. With recognition to RSUs and SRRs, there would be a much wider or a broader recognition to these kind of instruments. 62(1)(b), 42, all these sections. I'm not going into the sections, but all these sections are now being modified to basically account for these new mechanism. Also, what we see here is from an M&A perspective, this will basically bring in a lot of certainty in the M&A space. There will be a clear-cut structuring arrangements for incentive plans and earnouts, particularly for PE and VC investors. SARs, in our experience, have been a very attractive investment option, or rather a security option, and we see a lot of upside which you would see in transactions where RSUs and SARs will be issued. Also, I think by recognizing RSUs and SARs, the government has tried to show that they are aware of the pulse of the market. They are aware what the startups are looking at, and they are trying to basically address those concerns. Another important aspect which has been brought about in the new bill is the concept of buyback of shares. Now, buyback of shares is not a new concept, but it is coming in what I would call a buyback 2.0 avatar. Now, a buyback which is primarily in the current law is only a once a year kind of an arrangement with which can be basically be used for capital repatriation out of fixed assets, sorry, out of free reserves and profits. Now, what would happen is that the government has allowed basically two buybacks, provided that there is a minimum gap of 6 months between the two buybacks. Those have been permitted. The caps have now been relaxed. We don't know what the new cap would be, but the 25% cap has basically been relaxed. Possibly in the upcoming rules, there is a possibility that depending on the class of companies and the kind of cash balance that they are maintaining, their free reserves that they are maintaining, there could be a different quantified amount of buyback limit which might be introduced. Now, what we also see here is an aspect of ease of doing business. The requirement of solvency affidavits has been done away, and this would now be accepted by a self declaration by the directors. How we look at it, this would have a big impact on the M&A sphere. Uh, this gives investors a lot more flexibility to exit from the companies. In multiple instances, we have seen there where there is a windfall year or there is a big asset purchase happening. Depending on the time of the year, depending on if there has been a buyback or not, investors, though they want to take out money, they are unable to do so because of various constraints. This kind of an arrangement where you are enabling multiple buybacks in a year, also trying to keep some kind of control with implementing a 6 month gap. I think this is a pretty balanced approach and will be looked at pretty favorably by the market. Another concept here, which has been basically brought about and which will again be pretty relevant for all of us in the corporate sphere, is the inability to convert a trust into a LLP. Now, most of the AIFs currently in India which are operating under a trust model. Now, what the proposed bill basically will bring about, if in case it is legislated in the same format, is a statutory conversion route which is coming in for the first time. Now, when you are statutorily allowing an entity to convert, the biggest implication from a M&A side is that you are doing away with the requirement of there being a particular instrument to effect that transfer. And the moment you negate an instrument, which is also there in case of a scheme, so there is a slight difference here. A scheme is also a kind of a arrangement which is recognized by the act, but there is an instrument requirement for effecting that transfer. When you have an instrument requirement, that leads to stamp duty incidences. What would happen here is that when there is a statutory conversion of a trust to an LLP, there will be an automatic vesting of assets and liabilities which is contemplated. The bill also talks about continuity of contracts and proceedings. Now, the impact of that would be that the AIFs, which are currently possibly looking at converting into LLP for various tax or basically operational reasons, would look at these kind of provisions for conversion themselves into LLP and be regulated. So if we look at the regulation mechanism also, in the order of sequence, of course, Companies Act and then LLP Act, and then there is Regulation of Trust Act, which is primarily contract governed. The endeavor here is not just to encourage LL or basically trusts or AIFs to come to a more regulated framework, which is provided under the Companies Act, but also to give them some kind of an incentive to basically move from one model to another. This would eliminate the need for contract novations, and plus the consent requirement also has not been kept very onerous. The consent requirement has been kept broadly at 75% of the investor consent, which we feel is a pretty reasonable kind of a consent requirement, which is more like a special resolution kind of a requirement which is being introduced here. The next topic which I would be dealing with here is about the reforms which are proposed in the merger and amalgamation space. The consent threshold for a fast track merger has been brought down from 90% to 75%. Uh, but bigger than this, because of course we all have in this practice have seen how successful or unsuccessful the fast track merger scheme has been. Of course, the government took the initiative to basically bring in small companies and startups into the realm by the 2025 amendments. But I think this endeavor to bring down the uh, consent requirement to 75% could possibly provide some impetus to fast track mergers. But the biggest change, or rather a constructive change, which I see from as an M&A council here, is the requirement to do away with two NCLT jurisdictions. In my experience, what we have seen is that whenever a big corporate is going on for a merger or a rearrangement, the biggest challenge, which is time consuming for them, is that they are looking at not managing two NCLTs, and therefore they would primarily look at moving their registered offices to a single jurisdiction so that they are doing away with the hassle of managing two NCLTs. A single NCLT jurisdiction is, I think, a very, very welcome change. And you would see a lot more corporates basically, because this would actually reduce the timeline which is currently envisaged in a group arrangement. Most of these groups, except a few, have their registered offices spread across states, and I think this is a welcome move, because this would result in faster deal execution, and of course this would also simplify a lot of procedural framework. Another aspect which has been brought in by the bill is an IFSC foreign currency regime. So we are all aware about the gift city and the big strides that it is making. But from a Companies Act perspective, I think the existing provisions of the Companies Act were providing, rather were being some kind of a roadblock for these gift city entities. Now, the bill proposes that the entities which are in IFSC can issue foreign currency, their capital in foreign currency. They can also maintain their books in foreign currency. The implication of these changes would be that this would basically eliminate foreign exchange fluctuation risks. This would also basically give a lot of confidence to the investors, because they are not worried about cross-border structuring. They are allowed to basically project, and the government also is in a way projecting the gift city as a global hub. What is being contemplated here is, and in fact, just to add to this, I think this would basically cement the gift city's standing, which is there, akin to a DIFC or other regimes which are in Dubai or other jurisdictions. So this will cement further the gift city standing there, because you are now bringing up the gift city at par with the foreign jurisdictions. Uh, I think the second last slide in my presentation is basically on the role of IBBI as a valuation authority. Those in the M&A sphere are very well aware how the valuation exercise is practically done. We have all the laws in place, but typically how a valuation is done is that the commercial team decides a valuation, goes to the valuer and says, "This is the valuation that we want," and they manage to get those valuations done. What is targeted here is basically sorry. What is targeted here is basically to have official board to basically uh, have a control or authority over these valuations rules and the people who are conducting those valuations. And if you see, this is one provision where you will say very severe penalties would also be imposed on valuers, including imprisonment. this is one of the few sections where the new bill also envisages imprisonment, where in case it is found that a valuation, or rather the valuer, has acted in a fraudulent manner. So again, there would be a lot more reliance on valuation reports. The only downside practically which I see with this is that this will result in longer deal timelines. Currently, the valuation reports were pretty much available between a 5 to 7 day window. With a lot more scrutiny on the valuers, what we envisage is that the valuers will, of course, do their thorough job, but from a timeline perspective, the M&A councils will have to factor in a longer duration for valuation sign-offs. Okay, so just to summarize, I think we are bang on time, just keeping 10 minutes for or 12 minutes for question answers. I think the slide here basically summarizes the key takeaways of the bill from an M&A and a transaction landscape perspective. Of course, there is a shift from criminal to civil penalties. The endeavor is to provide greater flexibility in structuring the transactions and to provide exits to investors. As we look at it, the endeavor is to basically incentivize performing companies, compliant companies with only procedural lapses, to not spend their time and money on procedural compliances in case of a default on proceedings, but rather to come up clean, go for a settlement, clean their books, come back and start focusing where their focus belongs, which is in doing business. At the same point in time, considering that there have been a shift from criminal law to civil law, as was expected, there is a stronger enforcement of outstanding penalties, which is now being looked at, which is obvious. You would not want to basically decriminalize offenses and also still have outstanding companies having outstanding penalties, and therefore there is a stronger enforcement on that. There is, of course, ease of doing business, which we can see from the requirement of doing away with affidavits and signed director certificates. And the impact on M&A and execution strategy is something that we've discussed across the presentations. So that's all with which I had to present. Over to
I
you,
think,
Dolly.
Anuj, I will just step in here for what is your take on the creditors' approval is still not in the meeting by voting and being present, but still it is in writing. So that's still, I think the bill should, or the JPC or somebody should put a presentation that should be at par with the NCLT under Section 230. So
Sure.
as an M&A practitioner, I think you can throw some more light whether is that, because for members it is 90% to 70% or 75% in the meeting and present and meeting or voting, whereas for the creditors it is still in writing, word is not deleted.
So
How
so
do
the
you look at it?
So the idea here is, Amita, is that as we look at it, of course, from a COC perspective in the IBC regime and otherwise also, the I think the government recognizes that creditors in India are still not a very structured lot. With investors and shareholders, it's a much more polished lot, which you would see also in case of EGMs and all. They would respond on emails. They would come for VCs. The government sector undertakings or the PSUs or the banks, I think the endeavor here is that they should be given an opportunity to be heard, because number of times I think it is not just about approval, it is also about getting your thought through as to why you are objecting to that approval. It would a 90% approval requirement, as you would look at, also to some extent pushes settlement of outstanding dues. So I think that has been the reason, but of course, this has been a request from the stakeholders for a long time. So we don't know
But I
what
think
the
at one side, the government is bringing two unlisted company also to come under the RD on the fast track under Section 233, but not keeping that 90%. Maybe they can keep it as secured creditors 100% approval, but for unsecured, maybe 90% of the members or the creditors present and voting in the meeting would have been at par with the NCLT. And that was the intention of our finance ministry also, minister, when she spoke about that fast track merger will be declogging the NCLT also for the small companies, for the other kind of a company. But this creditors approval is a big task for M&A for going into the fast track.
I would partially agree with you, but I think the rationale which the government
I
is coming
agree.
from is from looking at taking the financial or the banks and creditors separately and looking at stakeholders, per se shareholders, looking at them differently.
Yeah, yeah. I think Dolly, can step in and we will take the rest of the part of auditors, NFRA. There are more to discuss. We can take it in the series 2 of the same seminar or webinar on the Corporate Law Amendment Bill 2026. Thank you. There are a few questions,
Yeah, there
Dolly,
are
if
a
you
few
want, and
questions. Actually, some of our audience have posted. One is so both of them are
we
by
just read.
Rajeshwari.
I will just read out and I will
Yes.
reply also. Rajeshwari, she put that the bill state that the director concerned will vacate from the defaulting company. How will this defaulting company function without a director? Is it that they are supposed to appoint new director in the 6 months time period or to cure the default? No, Rajeshwari, I think there is a provision under 167 which says 164 says he's disqualified, but 167 vacation will happen only after 6 months. He is given time for 6 months to cure the defect, and then he cannot be reappointed, or he can continue till his time doesn't end, but the 6 months window is still open. 167, if all the directors vacate the office, then also there is a provision where the promoters can induct the new director. So yeah, how the company will function without director? Because there is a shareholders will definitely appoint the new directors who are not failing in his duty. That's I think the bill is proposing. I think I gave the answer. The second answer also, Anuj, I am giving because it is relating more on the auditor side. The same question even I put. The bill does not contain the penal provision for the auditors who violate section 143.12. What is the rationale behind this? Is it covered under any other provision? Now, exactly, I don't know 143.12 what it talks about. If I may just see that 143.12, it talks about if any performance of his duty violate any reason to believe for the fraud, because fraud he has not done and he has reason to believe and he has intimated his fraud, he should not be, and he is giving the report to the central government, he will not be disqualified from the pin. He has not done the fraud, he has to report the fraud. If he is reporting the fraud to the central government, he should not be penalized. But my other point here was under 143.1 or 147.1, the company and officer in default are penalized with the penalty, whereas 147.2, it still continues with the fine for the auditor. So that is my question. I hope, Rajeshwari, I have given you the reply on 143.12. Sorry.
There is another question by Deepthi.
Can you read it out? Yeah, please.
Yeah, so she's asking, do you foresee seeing this as a condition precedented or can be a post-deal confirmation as well with regards to IBBI? So does the valuation now become a two-step process? Are we creating the valuation and thereafter getting IBBI's blessing?
Anuj, if you would like to take it up.
No, that would not be the case. The IBBI is very much a regulating authority. So when a valuation is given, it is presumed that the valuer has done their job in a fair manner. The authority basically will come in case there is a complaint and it is suggested that the valuation report which has been issued by them has been issued fraudulently. So I don't see a case where there would be two valuations, or you will go and seek IBBI's blessings for each valuation. I hope
It
that
is
answers
just
you.
like an NFRA also. If the auditors there is a disqualification or misconduct, professional misconduct, then it will go to NFRA. Same way,
It's a
valuer,
regulatory authority. Yes.
regulatory authority. Yeah.
And
I
there is
think
one
somebody
more
wants to
question. Yeah,
speak.
there is one more question from Rajeshwari again. She's asking, the bill states that the director concerned will vacate from the defaulting company. How will this defaulting company function without directors? I believe that was this answered, Amita, by you? Is that
I
yeah,
was.
correct? Yeah.
I think
So
there was somebody who has raised the hand. He here or someone. If you can just see if he's still
yes,
there. Yeah.
yes. So in fact, I would encourage audience if they have any more questions, they can put it in the Q&A section.
Yeah. Here you can put in the questions.
Yeah, we
question
have
is-
one question from Krishnan. He's asking about fine versus penalty, which is more unwelcome for investors, which is better from compliance point of view.
I think we both can reply, but I will just initiate and start. I think fine versus penalty. Fine, you can go to the judiciary, and there is chance that it can be reduced further. Whereas penalty, there is a minimum and maximum. Regulator may, he even if he wants, he can't. There are certain instruction that it's repetitive, or if it is public interest involved, they can reduce. But I personally find fine would have been better. But now to declock from the NCLT, regulator is taking up adjudication maybe faster than the compounding. Maybe Anuj, your views here.
Sure. So as I look at it, I rather prefer penalties because that gives from an M&A perspective, it brings much more visibility as to in case a particular act has been done, what is the consequences. If as Amita rightly mentioned, because it was fine, it was adjudicated a lot, there were a number of proceedings, and from an investor or a M&A perspective, it created a hogwash which would continue for a long time. With penalties, you have a clear cut visibility as to what is the minimum amount and what is the maximum amount of outgo which is going to happen from an investor perspective.
True. But the challenge is with the the regulator cannot go beyond prescribed. Whereas if you go to the adjudicating I mean, in the compounding, there are chances that they can still levy lesser fine, because fine was always at the discretion of the adjudicating or the NCLT bench member. So that we have pleaded, and then we could get away with the lesser penalty than the prescribed, I mean, lesser fine. That's a added advantage. But having said so, even penalty is easier, and adjudication is easier. You can make the default and clear and go away by paying some monetary compounding. It's not a criminal tag where you are
Yeah.
threatened, or you have to go under the longer process of NCLT for compounding matters.
All right, thanks. And one more question from Sushil Kumar Jain. He's asking, can you please explain what would be the benefit to the AIF from conversion as trust to LLP or company?
So, from an operational perspective, Sushilji, sorry, but this is pretty. There is a long, there's a very detailed response to this, so possibly that can be dealt with later. But from an operational perspective and from a tax perspective, I think you will see a lot of companies which are currently AIFs moving towards the LLP structure. I don't think they are looking at conversion of LLPs into companies right now. What is contemplated is only AIFs into LLPs. And I think that is pretty much there because LLPs continue to be less regulated as compared to companies. So the shift is smoother. And from a tax perspective, I think from a functioning perspective, lot of AIFs might prefer LLP route.
Okay, so I don't see any more questions in the Q&A box anymore. So I believe most of the queries are already responded to. Okay, there is one question. Okay, so yeah,
I think
yeah.
he still raised the question, his hand, but I think if you can put the question.
No, she did mention that whatever query
Okay.
she had was already answered by you during the session. So we don't
Okay.
have any questions anymore. And in fact, if any of you all have any follow-up questions or queries, please feel free to write into us at info@incorpadvisory.in. We are going to come up with the second part of this specific topic, which will again dive deeper into this specific amendment. And we also encourage all of you to please scan this QR code and follow us on LinkedIn for also other series of webinars that where we cover ESG, Gift City, we cover cybersecurity, and a lot of other variety of topics. And so yes, thank you everyone for joining us today. Thank you, Anuj. It was very insightful, great insights. And Amita, thank you so much. We will see you all again very soon in the next one.
Thank you. Thank you,
Thank you,
Dolly.
everyone.
Thanks a
Thank
lot.
you.
Thank you,
Thank
Anuj.
you. Bye-bye.
Bye-bye.